Maurice,
Good morning.
you can hear me?
I can hear you loud and clear.
Okay, great. I will be present today, but without video. So,
Okay, that's not a problem.
okay, great. Thanks.
Have to install Linux. Where is it? What's it pointing at? Didn't work.
Hey Liz, it's 9:30. Let's get started.
Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this Monday, February 7th, 2020. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinance of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
Thank you. Can you call the roll, please?
Sure thing. Ms. Barnes?
Good morning, Ms. Barnes, present.
Good morning. Ms. Brown?
Present.
Ms. Vaith?
I am present.
Ms. Britt?
Here.
Madam Chair, we have a quorum.
Great. All right, let's see, we have no postponements today.
That's correct.
It might be a record.
Yes.
Good
And
day.
Madam Chair, I don't see any council people in attendance.
All right, okay. Well, we'll start with the first one.
All right. We'll begin today with calendar number 21-206. This is at 4533 Warner Road. This is a Public Works invoice WO-1182559. A TAR catering and event planning appeals under the authority of section 76-6B of the Charter of the City of Cleveland and section 329.02D of the Cleveland Codified Ordinances from the decision of the hearing officer dated December 9th of 2021 to uphold the City of Cleveland's Department of Public Works to issue invoice WO-1183559 regarding abating nuisances, parenthetically, that's grass cutting, at the subject property. This was filed December 30th of 2021. And with that, to Ms. Brown for the oath.
Thank you. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand. Reply, I do. State your name and your address, please.
My name is Jesse Davidson, and I do swear. My address is, you want the building address or my home address?
Your home address, please.
My home address is 410 Edge Park Drive, Garfield Heights, Ohio, 44125.
Anyone else for this case? Okay, Madam Chair.
No,
Thank you.
I'm
If you're
sorry,
not
hello?
if you're not speaking, please mute your phone, please. You can hear some background. Okay.
Yes, this is Ariel Cook with the Department of Assessments and Licenses. I'm sorry, can you hear me?
Now we
Yes.
can.
Are you
Yes,
testifying in this case?
I appear to
Ariel,
be
you
the only
testifying?
person on the, city side, so I'm going to say, yes, I do. My name is Ariel Kolk.
And the address, you can give your work address.
601 Lakeside Avenue, Cleveland, Ohio, 44114.
Now, Madam Chair.
All right, thank you. We'll do the do we need history with the invoice? I think we just do legal standard. Yeah.
Right, that's correct.
Thank you, Madam Chair, members of the board. Appellant is appealing an administrative decision. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you. Okay, Mr. Davidson, explain to us what happened here.
Well, I just received this maybe less than a year ago, but they're saying that they cut the grass in October of 2020. And at the time, it was the pandemic, and I'm an essential worker. So in order for me to maintain and take care of my family, I had to travel abroad for work. But my thing is, I'm not disputing that they didn't cut it. For one, they're saying that the building is abandoned. When I sent Natasha all the utility bills since we purchased the building, the utilities been on. I've been taking care of the building. It's just that we're working closely with Slavic Village, trying to get the work permit to get the building open. So out of circumstances that is kind of out of me and my wife's hands, we can't get the building open yet, but in the process, me and my wife owned the building since 2019. And if you look at the history, we've never had a grass cutting issue. So I have someone cut the grass diligently all the time. So they're saying that in October, they cut the grass, which is kind of like the down season of it. But my issue is, like I say, I'm not saying they didn't cut the grass, but they're charging me $1,200 and not for the whole property. They're saying that they're charging me $1,200 for just cutting along the tree line, saying there was some debris there and they cut along the tree line. Well, that's $1,200. Now I understand if they cut the whole building, but just this tree line right here, $1,200, I didn't understand. And again, I have someone that cuts the grass. I don't have by then 2020, I usually have my landscaper. Every time he cuts the building, he also does debris removal for me. He sends me a picture. Well, by me not knowing that they even cut the grass, I couldn't dispute it. So I don't have the evidence going back that far. But if you look at the history of never having a ticket or anything on this property, not only the fact that I take care of the landscape and everything, I'm also fighting with, by not being open, illegal dumping. So if I get 5 free dumps through the city a year, and every year I'm utilizing that because I'm not able to open right now, and people are constantly dumping on my property. So I've been in this community all my life. So I'm real, I speak highly of my councilman Bishop. I speak with his office a lot, and I'm doing what I can on my part to try to maintain the appearance of our property and the community. But $1,200 to just cut the tree line seems a bit absurd. Like, I don't know the guidelines of it. Now, I have a pretty nice parcel. So if they had cut the whole parcel, I can understand that amount being pretty much being approved of, but just $1,200 for the tree line and to be added to the taxes is a bit extreme, especially when, like I say, we're doing everything on our end to try to get the building up and running. It's just a process. I'm working with Merlin at Slavic Village, and we're doing everything we can on our part. But like I said, it was during the pandemic, and I had to work. I had to go abroad to work in order to maintain work, in order to keep taking care of my family. So October was the kind of like my down season. So I wasn't having the landscaper cut the grass every week, week and a half, as he pretty much does. By being October, I figured that, you know, grass is not growing as it is in the middle of the summer. We usually do it maybe every 3 weeks to probably maybe a month. So for her to, like, again, Natasha said that they did cut it in October, and I guess they took pictures and everything, which I'm not saying they didn't. All I'm saying is, if you never had that type of issue with me, and I'm known for taking care, and it's not the only property that we have in this area for 4105, I feel like it should have been some type of leniency, or maybe work with the community a little bit better due to the situation of the pandemic, you know, where everybody was struggling trying to keep their head above water. It just seems like $1,200 for one single grass cutting seems a bit extreme. And that's really all I have to say on that.
Okay, thank you, Mr. Davidson. I need some points of clarification here. So they cut this in 2020, and maybe this might be more for Ms. Kolk. I'm trying to understand, well, for one, it's February 2022. So why are we just, hearing about this appeal now? And $1,200, normally those grass cutting fees are, like $300 and $400. So is this like some accumulation that's happened with the fee, or I'm a little confused here. So Ms. Kolk, maybe you can weigh in on that.
I will certainly try. So on the actual invoice, if you look at the invoice date, that was April 22nd, 2021. So when my department received the charges from City Works, from Parks Maintenance and Properties, we processed them and invoiced them out. The charge is based on the size of the lot. So the square footage. So it's a flat fee charge based on the square footage that shows on the county auditor's page.
Okay.
But they didn't cut the whole lot. I'm sorry.
Mr. Davidson, I'm listening to Ms. Kolk right now, so hold on.
Oh, I'm sorry.
It's fine. To his question, I can't speak to that part. My department simply receives the information from Parks Maintenance and Properties. We create an invoice and get it out of the door. So I really can't speak to the charge amount beyond knowing that it's based on lot size.
Based on square footage. Okay. And so, Mr. Davidson, you got this invoice at some point last summer. And what did you do?
In the spring.
In the spring, okay. And so, Mr. Davidson, once you got this invoice, what was your next steps? You said you talked to Ms. Brewster. Did you try to work with her to alleviate this, or what happened there?
When I spoke to, I guess her name is, I don't know her last name, but I know her first name.
Natasha.
Yeah, when I spoke to her, it was honestly, it was no empathy on her end. She pretty much explained to me what they cut, and I guess it was some tree brush along the line of the tree lawn. So I was explaining to her that majority of my property is parking lot. So I do have, because I was asking her, like, well, because I was under the impression that they actually went inside of the gate and cut the whole grass behind the building and everything. And she says, no, they only cut the tree line, which you see on the picture, is just along that black gate. So you have a sidewalk and you have a little strip that goes from maybe the back of that black gate to the beginning of Warner Road, close to the sidewalk. So that's the only reason I had an issue with, and the reason that we're just now seeing this in 2022 is because I never got the notification. So she said that wasn't on her. She has nothing to do with the way the postal office delivers the mail, this, that, the third. And I'm explaining to her, like, well, is there any way that, like, I can understand me being charged, but that's a bit excessive. Is there any way that we can kind of like maybe work out something with the payment as far as how much you guys charge me and how much debris did you guys pick up to warrant it being $1,200. So with the lady saying that it's going by square footage, majority of my property is parking lot. So to charge me grass cutting and majority of my property is parking lot still seems a bit absurd. I just feel like if you're gonna assess everything, assess it according to the nuisance ticket. So if you would have said, well, we assessed your parcel and this particular amount of acreage is grass, so we're going to charge according to this particular acreage that's grass and not the particular. So you charge me for the building, because that's part of the square footage, the parking lot, and also the grass, which the tree lawn on the outside of the fence doesn't even count as my acreage or my measurement amount. That's outside of the fence. So what you cut is outside of the property, but you're charging me
Okay.
for the square footage of the property.
Okay, so this is coming to us fairly late in the game because you are on record saying that you did not receive the invoice. So when you did not receive the invoice, you couldn't address it at that point. And so now you're at the point where you owe the city $1,200 for this cut.
That they're going to add to the taxes.
Is that, yeah, okay. All right, Ms. Colt, is there anything else from the city's point of view you want to add here?
From the Department of Billing, there's really not much else I can add. We just receive the information from Parks Maintenance and create the invoice.
Okay. Yeah, normally Natasha is here, so I'm kind of surprised that she's not on this call.
Madam Chair, on that note, I did receive an email from her. I had expected
Okay.
that she would be here today. She did state that a hearing was held, but Mr. Davidson did not show up to the hearing.
Okay.
She stated that regarding the A-tier catering and event planning, they had a hearing on December 8th, 2021 at 10:15. Neither Jesse or Rita Davidson showed up. And that's all that I have for that.
Okay, so we got the invoice, we got it late. They gave you a hearing to dispute it. There was no show at the hearing. And so now you're here at BZA. So from what I'm seeing here, although we might all think that $1,200 is a lot of money, at the point in time of this cut, the city was not arbitrary or capricious in doing the actual nuisance cutting. But right now, and you have said that on record yourself that you're not disputing that they cut it, and that you had to be away doing other things to maintain your lifestyle. So I think I'm just going to open it up to my board
I never
to.
received the thing showing that they cut it. Natasha said she had pictures, but she never showed that they cut it. I'm just going by Natasha's word. So I
No,
never.
I got you. I got you. I'm just trying to sum up the case before I bring in my board members. So right now, he owes the city $1,200, but he's not disputing that they cut it. I think he's just concerned about the price of it. So, board, I'll open it up to you for any questions or want to work out a solution here.
Madam Chair, I do have one question. Mr. Davison, were you aware of the hearing in December where Natasha says you did not show?
Yes, I was aware of it. And again, I tried to explain to her because I did call her. It's just that my job has me, I travel for my job, I drive trucks. So I was trying to make it back in time. And sometimes in the process of my job, things don't go according to plan. So I got back too late. And I did call Natasha and I let her know. And she said it's out of her hands. She gave me a number to call to set up a payment plan. And I hate that I got the type of job that I have to travel.
Okay.
So, but I deal with disaster situations, like FEMA situations, where if I'm called to go, I go. And if I tried to make it back, I couldn't, and I did explain that to Natasha.
Thank you.
Madam Chair, this is Liz.
Yes.
In the past, we've had Ms. Wagner weigh in on situations similar to this. Often, or in the past, I wouldn't say often, we have sent it back to Ms. Brewster to get a ruling. So is this something we should do in this case, Ms. Wagner?
Yeah, I was tossing that around in my head too, so.
Yeah, I'm not sure what we've done in the past. The question is whether the board can find the ruling of Ms. Brewster arbitrary, unreasonable, and capricious when the property owner did not show up at the hearing. So I'm not sure which way that's come out in favor of the board saying they can't hear it at all, or just taking that fact and making a decision based on that.
Madam Chair, Mr. Davidson has his hand raised.
Mr. Davidson?
Yes, I did miss the hearing, but as soon as I was able to try to rectify it, I was on the phone, I was doing everything that I had to do to explain the situation. So it's not like I missed the hearing and I tried to correct it as soon as I was able to. It's just that I wasn't able to be there. And I did, I think the hearing was on a Thursday. I believe I spoke to Natasha on a Friday. And like I said, she stonewalled me, told me, hey, you're gonna have to set up a payment plan. And that's when I took it upon myself to come downtown and see, was there anything else I can do for this matter? So I hate that I apologize that I did miss the hearing, but I did, as soon as I was able to, get on top of it, being responsible and not just.
No, we understand that. We're just trying to get all the facts in the case in order. So thank you. All right, any other board members?
Madam Chair, this is board member Ms. Barnes.
Mm-hmm.
I'm listening at what he's saying, and I'm listening at what pandemic we are definitely in, and I'm listening at his job that he had to be out of town. This is going on in his life. And $1,200 to me is kind of steep. Is there any kind of way maybe we could cut that in half and just demolish with this case today? Give him some kind of break because he does drive trucks, and we know all over the country there's a shortage of truck drivers. So I'm just asking, is there some kind of way that we can maybe move this forward or do whatever we can do to help him? Because we have cut cases in half before, the prices.
Yes, we have done that. There was more of a clear picture though. So this is where I am. So Lori, I'm gonna come back to you with this. Is this something you think we can rule on today?
I think you can. I mean, you could send it back to Tasha for a hearing. I think that it sounds like there's been a lot of communication between the appellant here and licenses and assessments, and that might just be, I know, wasting everybody's time. But if you feel you need a clearer understanding of the facts, then you could send it back for hearing, or you could rule against the appellant on the basis that he failed to come to the hearing.
Okay. All right, board members, we do have a couple of options here. We can kick it back to license and assessments with Ms. Brewster, and they can find out if they can work out a payment plan with him. It gets another hearing date. Or we can take, Ms. Barnes made a suggestion that we could just go ahead and move forward with this case and maybe cut the fine in half so that the appellant can move on, pay the city, you know, what we deem it necessary, and then he can move on. So, what do my board members have to say? Well, you know where Ms. Barnes is. So, Ms. Brown, Ms. Faith.
Madam Chair, this is Ms. Faith. Um, the mowing took place outside the fenced gated area. It is my feeling that $1,200 seems like a steep price to have your tree lawn mowed, even given if there was debris there. So I am inclined to agree with Ms. Barnes that we should reduce the fee, make a ruling, and get this behind the appellant so he can move forward. I'd welcome any other comments from the board.
Ms. Brown, how do you feel about that?
I support the action proposed.
Okay, I'll take a motion then.
All right, Madam Chair, with that, I will motion that we reduce the fine by 50%, so from $1,200 to $600, and that we go ahead and approve that fine assessment for the appellant so that this can be finalized today.
Okay, can I have a second?
Ms. Barnes, second.
Thank you, Ms. Barnes. So just for clarification, this means that we are keeping the decision of the city. We're both upholding decision of the city, but as far as the fine is going, we're going to reduce that. So just so everyone has understanding of what's happening here. All right, go ahead, call the roll, Ms. Cooper.
Thank you, Madam Chair. Ms. Barnes,
Yes.
Ms. Brown,
Yes.
Ms. Faith,
Yes.
Ms. Britt.
Yes.
Calendar 21-206 is granted conditionally. We will we'll ratify this case next week, and we will send the appellant a letter.
All right, thank you. Good luck, Mr. Davidson.
Thank you, I appreciate you guys.
Good luck to you, sir.
Thank you.
Madam Chair, we're moving on to calendar number 22-001. This is at 1453 West 116th Street. Christian J. Riemenschneider, owner, proposes to convert a 4-suite apartment building to a 2 fee simple dwellings and split use of a 2-car garage in a B1 2-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 4. And with that, to Ms. Brown for the oath.
Thank you. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address, please.
Madam Chair, I'm not sure we have anybody for this case today. I don't see any of the people that we sent out invitations to.
All right, we'll move on to the next one and see what happens. Ms. Faith?
Okay, Madam Chair, this moves into the BZA bundle section of today's agenda. So our first bundle is calendar number 22-002, 22-003, and 22-004. Respectively, these are at 1907 Freeman Avenue, 1911 Freeman Avenue, and 1915 Freeman Avenue. Joe Shura, owner, proposes to erect a 2-story frame fee simple single family townhome residence with an attached garage in a D1 two-family residential district. And that would be the same description for all three. And the applicant is seeking relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are two for each one. The second of each note section 341.02, which states that approval of the City Planning Commission Department is required on each of these. And with that, to Ms. Brown for the oath.
I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address, please.
I do. My name is Joseph Chura. My home address is 2143 West 6th Street, Cleveland, Ohio, 44113.
I do. Matthew Moss. I'm with the City Planning Commission.
I do. Corey Reardon, Tremont West, 2406, Professor.
Madam Chair?
All righty, history of the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. There are no variances on file for this address, for these addresses. And in the more recent history, we found that for the 1907 address, a permit was issued in 2018 to demolish a two-family dwelling. For the address of 1909, in the same year, a permit was issued to demolish a single-family dwelling. And then for the address of 1915, in 2002, we found that a permit was issued to board and secure first floor openings. And that's all that I have, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the garage placement requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code. And I would just remind the board that number 2 of each of these cases, the approval of City Planning Commission is required, is not something the board can waive or grant a variance from. So we're really just dealing with the garage placement on each of these.
Thank you. All right, Mr. Chura, are you the spokesperson for this?
I can be. I don't know if Matt wants to speak first, but I'm happy to speak if Matt tells
No,
me.
Matt's not presenting this. Matt's
Okay,
not presenting this case, so you go ahead.
Yeah, so the project as seen in the plans you have is a development for 3 single-family homes, just under 2,000 square foot each. The townhouse code is utilized in this case in what I think is a creative way. It doesn't look like your usual townhome. It's not the standard boxes smushed together. It's a solution that has gable roofs, which is very contextual to the neighborhood. The local block club certainly prefers that kind of architecture, and this has been supported by the block club. The difficulty with not having the garages facing the street, which is the heart of what the variance I need, is that these lots are only 28 feet wide by 66 feet deep, and even when they're replatted, as you see in the drawings, they're still very narrow. To get the garages to face the side or the rear would require at least one of the units to go away. It would also require that the majority of the site be paved, which is not something that's good. So this solution with the garage doors facing forward is what I have. It's important to note that the garages, however, are set back over 20 feet from the main building line. They will not be perceived as garage doors right on the sidewalk, which I think is the true intent of the prohibition in the townhouse code. And I guess I'll also state that the project has been supported by the local CDC, and it did go to Planning Commission and was supported there as well.
Okay, thank you. That's a good segue to Mr. Reardon. Go ahead.
Yes, thanks. I just want to confirm everything that Mr. Churist stated, that it did go to Block Club and did go to the Economic Development Committee of Tremont West and was supported in both.
All right, thank you. Matt, City Planning.
Thank you, Madam Chair. I'm certainly happy to speak to this variance today. We spent several weeks working with Joe. He's also the designer of these homes. So he's not only a developer, but he's able to speak to how this should be designed. And I think Joe is pretty much correct. The typical townhouse form that we see is in a lot of ways driven by the placement of the garage. It's typically a 2-car garage, which requires much of the living space to be stacked above that. So here, we worked with Joe to come up with a solution that, while it doesn't meet the code due to this garage placement variance, most of the living space is on the ground floor, which is also a goal of ours in terms of promoting more walkable streetscapes and more walkable urban environments. And we also try to work with Joe to get this as compliant as possible with the garage placement code that applies to detached single and 2-family homes, where that's required in the rear half of the lot. And while we didn't quite get there technically, I think this still fits the intent of that, which is to separate the garage placement as much as possible from the pedestrian space and the living space on the ground floor. And really, given the depth of the lot, I think the conditions here are right to support this variance. So we approve this design and fully support this project.
And this was approved at Planning Commission?
Yes, that's correct. Because this is a 2-family zoning district, the townhouse code requires that the Planning Commission grant a use approval for this type of housing product.
Okay, great. Well, I definitely commend you all for working together with this development here, and the only variance you need is the garage. So I think that's really good. I will open it up to the board for any questions or comments or a motion.
Madam Chair, I think with the overwhelming support of this from the Black Club, the CDC, we've had testimony from city planning, and that the Planning Commission has approved this. I think the design is certainly fitting contextually with the neighborhood. And I think you're also correct. The fact that there's only one variance for the garage is a testament to how well everyone worked together on this and really problem solved. So with all that stated, I think we can go ahead and approve this variance.
Thank you. Can I get a second?
Member Brown, I second.
Ms. Brown with the second. We'll move forward with the roll call, just also stating that the numbers, as Lori stated earlier, number 2 in the list, we cannot grant. All right, go ahead.
Thank you, Madam Chair. Ms. Barnes?
Ms. Barnes, yes.
Ms. Brown?
Yes.
Ms. Faith?
Yes.
Ms. Britt?
Yes.
Calendar numbers 22-002, 22-003, 22-004 are granted. They will be ratified next week, and we will send you a letter.
Thank you all very much.
Thank you. Looking forward to seeing them in person.
Me too. Thanks.
All right, Madam Chair, we move on to our second bundle of today. And that is calendar number 22005 and 22006. Respectively, those are at 1889 West 54th Street and 1887 West 54th Street. Elmhurst Homes owner proposes to construct a 1,200 square foot single-family residence with shared driveway and side-by-side detached garage on a 2,897 square foot lot in a B1 two-family residential district. That is for case number 22005. For 22006, Elmhurst Home owner again proposes to construct a 1,200 square foot single family residence with a shared driveway and side-by-side detached garage.
Am I the only one that cannot hear Alana?
I don't know.
You're just fine.
Okay. And this time it is on a 3,070 foot square lot, also in a B1 two-family residential district. The owner appeals for strict relief of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are four for each. And with that, to Ms. Brown for the oath.
I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do. State your name and your address, please.
I do. Lawrence Apple, Elmhurst Homes, 26300 Village Lane, Beechwood, Ohio, 44122.
I do. Paul Began, Began Architectural Design at 15703 Madison Avenue in Lakewood.
I do. Susan Broadwater, 15703 Madison Avenue, Lakewood, Ohio.
Madam Chair?
Thank you. History of the property, please.
I'm here.
Okay, who else?
Richard Ramos, real estate broker, license number 700-195-669, 6942 Greenbrier Drive, Parma Heights, Ohio. Representative for Janice Henderson, who is sitting next to me.
Janice Henderson, 1895 West 54th Street, Cleveland, Ohio, 44102.
Thank you. Madam Chair?
Okay, history of the property, please.
Thank you, Madam Chair. There has been no change in the zoning since 1929. In our Records Administration Office, I found for the address of 1889 West 54th Street, a permit was issued to demolish a one-family dwelling, and that was in 1983. There were no records for 1887 in our Records Administration Office. There are no variances on file. And then in the more recent history in our Acela system, I found for the address of 1889 that a vacant lot cleanup fee was assessed to the property. And that's all that I have, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the minimum lot area, minimum lot width, yard and court spaces, and driveway width requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared with other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you. Mr. Began, are you going to be the spokesperson in this case?
I think I will be
I
the
am here.
spokesperson at first.
Okay, go ahead, Mr. Apple.
Yes. The history of this property is briefly as follows. I purchased the property in May. Plans were prepared, and the City Planning Commission, after notice to neighbors and a public hearing, unanimously approved a lot split on September 17th. The plat was recorded on September 29th. New permanent parcel numbers were assigned The plans were reviewed by the Housing Design Review Committee, and that brings us to the hearing now. I'd just like to state that we have designed homes that I think fit very well within the neighborhood. If you can see architectural site plan AO, which is shown on the screen, the houses are compatible with the neighborhood. The lots are approximately the same size as the houses in the area. This is similar to experience we have had recently on 2 houses with a shared driveway. You see on the screen now the area, the vacant land is on the lower left. The houses to the north are on the upper right, and the house to the south is on the lower right. The shared driveway is a scheme that I've successfully used is 6607 and 6609 Wakefield and on Franklin Boulevard. This is the design of the houses with a front porch. And I'd like Paul Began, the architect, to add some description of the design.
Yes, Larry, I think you covered most everything. Yes, this scheme was reviewed by the Housing Design Review Subcommittee, who are quite happy with the design and the layout. This was an unusually large lot, which is not very typical for this area. So the lot split was actually bringing the property more in alignment with the other parcels in the immediate surrounding neighborhood. Obviously approved by Planning Commission for that lot split and the scheme that we have before us. The houses themselves are really trying to work within the context of the neighborhood, having a gable front with front porches to address the neighborhood. And really the biggest thing with this particular project is that there is a shared driveway between the two to get back to the garages. But otherwise it is in character with most of the other properties in the neighborhood. We have maintained our side yard setbacks as is required for this one. It's really the area variance for this particular one. The way that the design is set up and the buildings are laid out on the site.
Okay, thank you. Ms. Broadwater, did you want to testify?
I have nothing to add. Thank you.
All right, thank you. All right, Ms. Henderson? I think you're muted.
Pardon me? Can you hear
Okay,
me
now
now?
we can hear you. Yes.
Okay, thank you. Richard Ramos speaking. I'm going to read into the record what we feel are objections to the grant of the variance. The first thing I will mention is Ms. Henderson never received notice of Planning Commission hearings, so she was never advised as to the lot split. I'll now go into the statement of request for the denial of the variances. A request for the denial of the variances is hereby requested by Janice Henderson, the neighbor and owner of the parcel immediately to the south of the plot of land, which is the subject of the herein. According to the 2015 Ohio City zoning chart, the rezoning process was reworked to make sense of existing property owners and for future development. The new code, which was implemented at that time, was put into place to make it easier for developers to navigate the city process. It is the opinion of Miss Janice Henderson, a neighbor and the original consolidator of the parcels, that the request for the variances is an attempt by the developer builder to circumvent the legal process. The builder developer, by his own actions, replatted the sublot without notice of approval or an attempt of hearing to Ms. Henderson. the very act of requesting a variance after recording of the proposed variances to the zoning code, which is the subject today, is not only immoral to the existing landowner, but also an unobstructed attempt by the builder developer to avoid zoning requirements within the spirit and intent of the code. Please note that at the time of the original consolidation of the parcel herein, all code requirements were adhered to by Janice Henderson, which would permit for the reuse or redevelopment of the property at a future date. It is also noted by Janice Henderson that the existing adjacent property owner, who is the existing adjacent property owner to the south, that the property was purchased by the builder developer on May 26, 2021, according to Cuyahoga County records. The title transferred to the builder developer with the full knowledge that the zoning code in place at that time. The builder developer thereafter recorded a lot split on September 29th, 2021, according to Cuyahoga County records. The builder developer, on his own volition and without notice of approval by the Board of Zoning Appeals, which is why we're here today. It's requested that the Board of Zoning Appeals look into the matter of whether there is actually an unnecessary hardship to the builder developer, as to the plat was originally consolidated and platted by Janice Henderson. Further requested is a determination by the Zoning Appeals Committee as to the proper and legal action by the builder developer of further lot splitting or subdividing without the prior consent of the committee. For the record, hereinafter are the primary objections to granting the variance. These will be presented by Janice Henderson, to which I now yield.
Hi, Janice Henderson. The variance request has been requested at the replotting of sublots. That is in conflict with standard procedure. Variances are to be granted prior to subdividing. Original sublot was replotted by me, previously owner of the property. Originally, replotting was done in accordance with the current Cleveland zoning code. The replotting followed the code requirements so that there would not be any unnecessary hardships for further redevelopment of the sublot for future developers. The builder herein is requesting 8 total variances, not 1 or 2 for a foot or an inch, is for 10 feet. A reduction of at least 39% for minimum lot size for parcel B1 and a reduction of 36% for lot size of B2. This pertains to section 355.4A of the Cleveland Code. The code should be enforced. A reduction in the minimum lot width of at least 37.5% from 40 foot to 25 foot. The original plat was designed to meet the criteria of the zoning with a 50-foot wide front lot. No unnecessary hardship was provided the development of the lot. This code should be enforced also. This pertains to section 355.404A. The developer builder is requesting the complete ignoring of requirement for independent yard and court spaces as required by section 357.02 of the zoning code. I request that the code be enforced as the original code requirements were met so as to not produce an undue unnecessary hardship to the builder or developer. The original plat took this factor into account. Also on the plat as presently recorded, there is no indication as to front yard, backyard, or side yard. The question of whether a 0 lot line is permissible, and again, another variance would be required and not requested in the application. Further shown on the current recorded plat, the proposed garage outbuilding straddles the 2 parcels, B1 and B2. Said construction would require granting of still another variance which permits said construction and again ignores code requirements. In summation, I request that the current code be enforced just as I was required with the property was first consolidated in 2006. I yield back to Mr. Ramos.
So in continuation, it's further noted that the owner, builder, developer has misrepresented the proposed construction of a 1,200 square foot dwelling at 1889 West 54th, and also the adjacent property at 1887 West 54th. Both representations are inaccurate when a calculation of the building foundations are performed. These calculations are derived from the drawings which the owner, builder, developer provided Ms. Henderson. A misrepresentation is not a supportable action by the Zoning Appeals Board. In further review of the proposed structures to be built, it is further noted that the proposed one-building garage is to be built straddling the property to subdivided parcels. As these are two independent parcels, any garage to be built would require it to also meet its own standard of setbacks. Further, there is no provision in the building code for the construction of a structure which straddles property lines. Another issue of concern pertains to the code requirement of 20 feet width for a driveway. The owner, builder, developer is requesting a 50% decrease in accessibility. No provisions are made for common usage, maintenance, ingress, egress, and the right to enter and access, and also for the turning around from parcel to parcel. It's further noted. Okay, I'm sorry, I lost my place here. The driveway itself will prove to be a point of conflict in the future. When vehicles enter and exit the dwellings, they will be done with less than 2-foot clearance. The safety and peaceful enjoyment of the occupants is questionable. Further, all we have to do is look outside at the snow accumulation, and a 10-foot wide driveway to the back makes no sense. A conditional use permit was not in place at the time of platting of the sublot. For this reason alone, conditional use permits with the variance requested should not be granted and the sublot revoked to the original design. The procedures were not followed. Unauthorized zone changes can affect lending by government agencies such as Fannie Mae and result in foreclosures in the future for future property owners. There was no request for variances that will be needed and not requested by the builder. Regarding section 329.04C1, there are encroachments beyond the required for the setback of the building. And I'll quote, "Any encroachment shall not extend beyond a diagonal line drawn from the near corner of any building extending beyond the required setback building line and located within such distance to a point on the required setback building line. The proposed building line is at the existing right-of-way and the encroachment defined is not met. Again, another variance will be needed, but was not requested." Section 55.04B pertaining to residence buildings and other main buildings in residence district. And I'll read, "In a residential district, no main building, irrespective of occupancy classification, shall hereafter be erected, established, or altered, except in conformity with the maximum gross floor area limitation specified in the table." The table is noted at section 355.04, in which it states that the minimum lot width will be 40 feet. For a one-family dwelling, there's 4,800 square feet required.
Okay, Mr. Ramos, we don't need the whole zoning code read back to us, so do you have any?
I'm just making a notation that ends my summation. Thank you.
Okay, thank you. Thank you, Mr. Ramos and Ms. Henderson. I'll kick it back to the developer, Mr. Apple or Mr. Began, if they want to respond to any of that before I move forward.
Yes,
Yeah,
this is Variance Apple again. Pardon,
Let
can
me
you
take
hear
a
me?
quick, I can, Larry. Hold on
Okay.
let me jump in real quick here,
Sure.
just on Mr. Apple's behalf, because he's the one that's applying for this variance. This is Paul Began. I want to object on Mr. Apple's behalf to the characterization that we have somehow circumvented the process with the city of Cleveland for this. I think that is an out of line characterization. I think this committee knows and is aware. I have appeared before you many times, as has Mr. Apple, and we've done nothing but follow the process as far as reaching out to our community planner, going through the Housing Design Review Subcommittee to get their review and approval, following the proper procedures and guidelines for performing the lot split, including appearing before the Plan Commission with the same presentation so that they understand where the houses sit on the lots. So again, I just wanted to object to the characterization that we somehow circumvented a process. And one last objection to adding any additional required variances. We work very closely with the City of Cleveland Division of Building and Housing and the Board of Zoning Appeals to make sure that any required variances are in fact on here before you. So the additional variances that Mr. Ramos has outlined, I think are not applicable. So I just wanted to put that on the record and then let Mr. Apple respond any further if he wishes.
Fine, thank you, Paul. I think if we look at Plan AO, which is on the screen, we can see that what is proposed is compatible with the surrounding uses to the use to the north, which is a small single-family house and a garage in the back, to the use to the south, which actually has two houses on a parcel of approximately the same size as these two houses, a shared driveway and a one-car garage. Ironically, this is the house that's owned by the person that's objected to this scheme. And they have two houses on one lot and a one-car garage. We propose two single-family houses and a garage that will hold 3 cars. So the primary point is that in addition to the procedural issues raised by Mr. Biggin, that as is often the case in the hearings before the Planning Commission and the Board of Zoning Appeals, the primary criteria is that the development should be compatible with the surrounding uses. And I think Plan AO does show that. I also want to say also that there is a recorded driveway easement that calls for the sharing of expenses and maintenance of the driveway. This was recorded with the plat. This is similar to the driveway easement that I used on the 2 prior examples of shared driveway houses that I recently constructed on Franklin Boulevard and on Wakefield. Finally, the one point in which I will agree is the houses are more than 1,200 square feet. 1,200 square feet was the square footage that was stated in the description by the Board of Zoning Appeals. The houses are approximately 17 by 40 or 16.8 by 42 feet, and they are approximately 1,400 square feet. So I do want to correct the record on that account, and that is what I'd like to say.
All right, thank you, Mr. Apple and Mr. Regan. I'll open it up to my board now. Well, before that, Maurice, are you city planning or do we have a planner on here?
Notice that Adam is logged in. I'm not sure if he wanted to speak to this. Can you hear me now?
Oh, I don't think he was sworn in either, so.
I was not sworn in, no.
Okay, Ms. Brown, can you swear Mr. Davenport in, please?
Yes, do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, state I do. Give your name and address, please.
I do. Adam Davenport, City Planning, 601 Lakeside Avenue.
Thank you. Madam Chair?
Thank you. Go ahead, Mr. Davenport.
Thank you, Madam Chair. We reviewed, I joined late, so apologize if I'm repeating information here, but I'll be succinct. We reviewed this project with our internal housing design review committee. Although, if you recall, we recently saw a new house proposal actually on the street about 4 parcels to the north on a much smaller lot with the same architect. This lot is a little bit larger. It's actually a little bit kind of abnormally sized and abnormal in width as well. So we felt like this lot, because of the width, I think it's like at least 50 feet towards the frontage of 54th, deserves an additional house rather than one. And Mr. Began and Mr. Apple came up with, in our opinion, a very smart plan to kind of restore some, restore 2 houses in the lot, but not be overly dense, and share a driveway, which we're a big fan of. There's a lot of houses that come to us, housing proposals for townhouses or single family houses otherwise, where individual driveways are required to adhere to our parking code. Essentially, I mean, that creates, you know, some spacing issues and lots of overall concrete and impermeable surfaces in the lots. But this is a shared driveway with a recorded easement that would have access to the back and adhere to kind of all our code elements that we want to see through design review. Also of note, I think in general in this plan is that, you know, one house could be built in this lot by right, but the way that would likely play out would be a much larger house and be requesting an additional kind of extreme square footage alleviation from our floor area ratio requirements in the zoning code. So I think these 2 smaller houses actually fit in better with the neighborhood on 54th overall, and you know, fit better into the context of the neighborhood. Thank you.
Madam Chair, I'd also like to point out that the applicant is not asking for any variances for side yards, which is typically the case when we have requests for to construct more dense buildings. Even their HVAC units are located properly in the rear. And again, just to point out, I know it was stated already, though, if you look to the north, those parcels are very consistent in size to what is being proposed here. And the architecture is also very consistent with the neighborhood. Also, I'd like to point out that variances 3 and 4 on both of them really relate to the establishment of a shared driveway and the shared garage. And then the first 2 are relate to obviously the lot size and the fact that we're going for a slightly more dense situation here than what's allowed by code.
Gotcha. Thank you for that. I'll open it up to the board now for questions, comments, or motion.
Let me see. Miss.
Excuse me, Madam Chair, was someone else trying to comment?
No, I don't think so.
Yes.
Okay.
We have this is Janice Henderson, sorry. We have an issue with snow down here. Really bad issue with snow down here.
Ms. Henderson,
yes,
that's not something you bring up here at the Board of Zoning Appeals. So I understand because we have one too. But We don't cover that
because of the
here at
fact
the BZA.
well, it's just because of the driveway. There's no place for the snow. There's no yard. There's no nothing. That's the only thing. I know it's not a complaint for you, but the issue is that when you do a driveway like that, there's no place for the snow. It's horrifying down here right now. So anyway, that's all I wanted to say.
Okay, thank you.
Mhm.
All right, go ahead, Ms. Faye.
Okay, Madam Chair, do I have any other comments or questions from the board? No. Okay. I think, given that the objections by the neighbors, they clearly had done a lot of research, and have passion about this. And we appreciate that input, certainly. We like to hear the opposing voices. We also have testimony from Mr. Davenport and Mr. Rulins from City Planning, and testimony from Mr. Began, the architect. The variances before us are, as stated, limited, not regarding front setbacks or side setbacks. And I think the point was well made that if a single family home, Mr. Davenport made this point, if a single family home were placed on this lot, we could fully expect that it would be of excessive size and also exceed the square footage ratio to the lot size, and would also not be in context with the neighborhood, which are chief concerns, certainly with regard to city planning. So with that said, the variances that are before us today support two houses with garages and a shared driveway that has been vetted through the plotting process. And the houses are architecturally in context with the neighborhood, both in size and architectural personality. And so with all that taken into consideration, Madam Chair, I move that we go ahead and grant the variances for calendar number 22005 and 22006.
Thank you. Can I have a second?
Second, Ms. Barnes.
Ms. Barnes with the second. Go ahead, call the roll, please, Ms. Kukla.
Ms. Brown?
Yes.
Ms. Barnes?
Yes.
Ms. Babe?
Yes.
Ms. Britt?
Yes.
Calendar numbers 22-005 and 22-006 are granted. They will be ratified next week, and we will send the appellant a letter.
Thank you very
Thank
much.
you.
All right,
Thank you.
thank you. Maurice, or Liz, anything from West 116th yet?
I emailed them. I don't see anybody. We would be looking for Doug Wall or Christian Ryman Schneider, and I don't see him.
I don't see them either. And we don't have any call-in users, so I would say they're not here.
Okay, moving on.
Okay. With that then, Madam Chair, the final bundle of Bundle Day today. These two cases were postponed from January 3rd, 2022. We have calendar number 21-184 and calendar number 21-185, respectively. They are 2312 West 5th Street, which is the rear, and 2312 West 5th Street, which is the front. Andrew Gottlieb, owner, proposes to erect a 4-story single-family residence with an attached garage in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record. And on calendar number 21-184, though misnumbered in the agenda, we have 4 excuse me, we have 4 items. And on calendar number 21-185, we have 5 items. And the number 5 is that city planning approval is required prior to issuance of a building permit. And with that, Madam Chair, we go to Ms. Brown. And not a moment too soon since my voice is giving out.
Okay, I am swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address.
I, Andrew Gottlieb, 3187 Old Brainerd Road, Pepper Pike, Ohio, 44124.
I, Adam Rosen, on behalf of Andrew Gottlieb, 5900 Detroit Avenue, Cleveland, Ohio, 44102.
I, Donna Joy. Oh, excuse me. I, Donna Joy, 2337 West 6th Street. Thank you.
I do Dan Raymer, 2318 West 5th, Cleveland, Ohio.
I do Corey Reardon, Tremont West.
I do Tony Coyne, counsel to Dan Raymer, 2318 West 5th.
I do Matthew Moss, Cleveland City Planning Commission.
Madam Chair.
Thank you. History of properties, please.
Thank you, Madam Chair. We had the history of this property on January 3rd. Just to bring you up to speed, it was a land bank parcel that the appellant is proposing to split to erect these 2 houses, the single-family houses on this lot. There was a dispute with the neighbor regarding an access easement agreement, and city planning was referenced during this during the discussion, and the board postponed the case to allow time for planner Matt Moss to be present to elaborate on if there was an easement agreement when the lot split was transferred and the other issues that were brought up.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the minimum lot area, minimum lot width, maximum gross floor area, front yard setback, and rear yard requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Great, thank you. Who's going to be a spokesperson for this case?
I will. This is Adam Rosen on behalf of Andrew Gottlieb, counsel to Andrew Gottlieb. Yeah, we're here today. I think the board wanted to hear from city planner Matt Moss. We objected to that delay last time. We believe that there was sufficient discussion about the easements and the precedent for granting the easements, and believe that the the variances. We believe that the easement itself, that was of conversation last time, is outside the purview of the board. But if the desire of the board to hear from Matt Moss today, we're looking forward to hearing his testimony and receiving approval on these variances. That is all. Thank you.
Madam Chair, this is Liz. Just to clarify that the ownership is no longer in the city of Cleveland's. It is actually in the ownership of the appellant at this time, just for clarification.
Okay, thank you. All right, the man of the hour, Mr. Moss, go ahead.
Madam Chair, if I may ask, what questions would you like me exactly to answer?
I'm going to open it up to my board on that because I didn't think you should have to come back. So I will have any of my board members that felt that was necessary to have questions for you.
I believe to Mr. Moss that you were not with us on that the day that we originally heard this. And we were really looking, I think, or would like now probably to have some summary of your expert insight on what happened and what the situation is with this particular case.
Okay, I can certainly do my best to give an overview of my experience with this particular development. I will say that I think my recollection of these events are based on the conversation interactions of the appellant and the neighbor who are here today. So I certainly encourage the board, if they're so inclined, to question them or their legal counsel. But to the best of my memory, this case has been underway for several years. This lot was originally a city land bank lot, and Mr. Gottlieb had applied for the development of this lot. It was one of the few lots that was still approved for a market rate private development at that time, pending the subsequent future agreements with the development corporation in this area and the council person on how to further dispose of land bank lots in the Tremont neighborhood. And the design of this was reviewed and approved by staff at the city that at the time that included staff in our department, including myself, and in the community development department and the housing development office and in the city land bank office. And it was after that approval and that review of the design and site plan, and that review consisted mainly of the city's housing development and design goals. We were made aware of a request from the neighbor, Mr. Raymer, that he would like a driveway easement on this property in order for him to develop the rear half of his lot. Because the city had already approved the sale and design of the home, we made a recommendation to Mr. Gottlieb that we thought this was a good idea. Certainly it would be consistent with the housing typologies that we see in Tremont. It's very common for lots of a depth of about this range that it's common to have a home in the rear, and it seemed appropriate from our perspective, as our responsibility is guiding the development of Cleveland's neighborhoods. That seemed appropriate, and we were supportive of it. It's my understanding that Mr. Raymer, the neighbor, had a conversation, at least one conversation, I don't know exactly how many conversations, with Mr. Gottlieb, and that Mr. Gottlieb was receptive to granting him an easement as long as Mr. Raymer was willing to share the costs of building this driveway. And I'm sure it involved some discussion of costs of maintenance and plowing and things like that. I was told by Mr. Gottlieb that he was unwilling to share those costs and wanted the easement to be granted free of charge. And Mr. Gottlieb was not willing to do that, and therefore the easement wasn't granted. So because we had already approved the sale of the land bank lot without that condition, and because we had already approved the design, we told Mr. Gottlieb to proceed with his project, as many property owners and developers do in this case. But like I said, that's a reflection of the history as it was relayed to me by these two property owners. And as I said, they're here today, so they can certainly speak to it with more authority than I can.
Thank you, Mr. Moss.
Yeah, we heard most of that at the last hearing. So I'm going to open the floor up for any more testimony. But
Madam Chair, I don't mean to interrupt, but I do want to add that I'm not sure exactly what this issue has to do with the variances anyway. So
they do not. I mean, in my opinion, they do not. But we're here.
Madam Chair, we do have Mr. Coyne with his hand raised.
Okay. And so any response that we get today, we did hear testimony on this case before in January. And so we do have that for the record. So if you have anything new to add that you did not testify in January, go ahead and do that. But if you have the same testimony that you had back then, we still have that for the record. So go ahead, Mr. Coyne.
Thank you, ma'am. Thank you, Madam Chair. And I won't repeat what was stated at the prior meeting, although we still believe that the legal standards are not being met. The housing typology and policy of the city is what's at issue, and that should probably be addressed when they redo the code. But since the last meeting, and when we spoke at the last meeting, we were asked to try to work something out with the adjacent developer, Keystone, which the principal owner is Mr. Gottlieb. And again, we represent Dan Raymer at 2318 West 5th Street. He's a homeowner and a resident of the city of Cleveland. They made a proposal after a conversation. We responded, and they have not responded back. Neither Mr. Gottlieb or his attorney have responded back, but we did make a proposal that would involve sharing in the cost of the easement. So since they haven't responded back, I'm assuming they don't want to have that discussion. So our position is still that we oppose the project unless and until the easement can be worked out. And I know they plan a lot split. So in addition to going back to planning for the approval of the development, they do plan a lot split. So there's going to be an easement no matter what. It's just a question of who has the rights and access to use it. I also want to note to the city that they are not in compliance with the land bank deed that they received. They're in violation of the express terms of the deed. Paragraph 1 requires that they actually get the permits within 90 days of executing the deed on July 2nd, 2018. And they haven't done that. They're to complete construction within 1 year of July 2nd, 2018. They have not done that. And our client, to some degree, acquiesced and didn't pursue any of that because it was presuming that they could work out the easement. So we actually request the city to revest the property to the land bank, and our client would be willing to reimburse the city if it could get title to the land bank parcel under the same economic terms. That way, Key State Development could simply return the property to be used pursuant to the land bank's typical process, which also usually favors an immediate adjacent homeowner. That did not happen here, but we would ask this board to not approve the variance as requested. I know it's unusual. Would we be willing to continue discussion with the adjacent owner? We would, but we were unable to make any headway during those discussions.
All right, thank you.
Madam Chair, we have Mr. Rosen has his hand raised.
All right, go ahead, Mr. Rosen.
I just wanted to update the board that we received Planning Commission approval for the lot split on January 21st. So we went to them and received that approval, and that approval is contingent on the easement granted to the back owner of the split. And so that's an internal easement between common owners that will be drafted and then granted upon the sale of that back lot to a new owner.
Oh, excuse me. I'm sorry, Madam Chair. My name is Donna Joy. I am the adjacent back owner. And the concern that I had was the easement would go from 28 feet down to 4. So that's a lot of square footage to be up on top of my house, which is a 4-foot allowance now. So I wanted to address that. Thank you.
Okay, thank you. Wait till we call on you next time, Ms. Joy, but thanks for that testimony.
Oh, I'm sorry. Excuse me. Thank you.
No problem. You just kind of cut into Mr. Rosen. Go ahead, Mr. Rosen. You can finish.
Sorry, I was just recapping the Planning Commission approval from last time and the easement that was going to be granted to the back lot owner. That's distinct from the easement that Mr. Coyne and Mr. Raymer are asking for, which we believe not to be the purview of BZA. Also, just to respond to the conversations about negotiations, we did receive those offers and have multiple conversations between this and the last meeting. Myself and Mr. Coyne and his associate, Ms. Weber, did have multiple conversations. The offer, just was not to our liking, and we believe it's within our property rights to accept or deny any offer to use the land for a neighbor's benefit, and again, outside the purview of BZA.
Thank you. Yeah, I think this case has gone a little bit beyond, the issues here are gone way beyond what we adjudicate here at BZA. So I just want everyone, and including my board members, to understand that we're not here to resolve anyone's easement issues or property issues with the next door neighbor. We're here to look at variances that have been requested by this appellant. So, Mr. Reardon, do you have anything else you want to add from last time?
Yes, Madam Chair, and I'm sorry if I'm rehashing something that was already discussed previously. The Block Club and Tremont West did not have an issue with any of the variances, but I would like to reiterate that we requested prior to the transfer of the land bank lot that that easement be provided. So it wasn't after the fact, it was prior to the transfer of that land bank lot, and we've been consistent on that all along, just to clarify. Thank you.
Thank you. And I believe, is it Terry? Anyone want to add anything else? Nope. Okay, anyone else that got sworn in that didn't say anything? Anyone? Okay. All right, looks like we have all the bases covered here. Okay, I'll open it back up to the board for any further questions or motion.
Madam Chair, do any of my colleagues have any other questions or comments? Okay, with that, moving forward, certainly appreciate Mr. Moss's testimony today and clarification, and also the final comments from Mr. Reardon, reiterating the position of the Tremont West in these cases. And again, we are focused on the variances that are before us on the agenda today. It is unfortunate that, as a side note, that the gentleman involved, all parties could not meet an agreement before you came back to us today. But that is not on our, excuse me, that is not on our issues before us. We are looking strictly at the setback issues and the variance issues on the agenda. With all that being said, Madam Chair, I move that we go ahead and approve the variances for 21-184 and 21-185.
Thank you. Can I have a second, please?
Second.
Ms. Barnes with the second. Go ahead, call the roll.
Thank you, Madam Chair. And this is with the understanding that the city planning approval has been achieved.
Yes, 341.02. Stuck in my memory.
Thank you. Ms. Brown?
Yes.
Ms. Barnes?
Yes.
Ms. Faith?
Sorry, I was muted. Yes.
Ms. Britt?
Yes.
Calendar numbers 21-184 and 21-185 are granted. They will be ratified next week, and we will send the appellant a letter.
All right. Thank you, everyone. Good luck.
Thank you very much. Thank you very much.
All right. We're at old business.
We're at old business.
We're gonna call West 116th, going once, going twice.
No objection, Madam Chair.
All righty. No one from West 116th is here, so we'll go ahead. No, without objection for number 2.
Without objection.
Without objection.
Okay. Liz, go ahead and explain this request for rehearing.
Thank you, Madam Chair. Here is the letter before you with the comments from the neighbor. He is requesting a rehearing at this time. I believe I sent this to you. I hope that you have received it and had a chance to read it. The appellant was sent the documentation clarifying the reasons that a rehearing would be granted by the board. And you could see in this case, they seem to be more so arguments that should have been and probably were brought up at the hearing. So they're more of an argument about the decision that the board made and so on and so forth. So I think Ms. Wagner may want to jump in on this, but they have appealed to the Court of Common Pleas. And so it may not be within the board's jurisdiction to even consider a rehearing at this time. And I will defer to Ms. Wagner.
I was going to ask that if they're already in litigation, like, can we?
Yes, that is correct. I have checked, and a notice of appeal was filed at the Common Pleas Court, which, while that case is pending, deprives this board of the jurisdiction to hear a motion for rehearing. I would also add that the standard for rehearing after the 30 days is very strict, and it can't just be an elaboration of arguments that were made before or new arguments. It has to be based on evidence that was not available at the time, and nothing here seems to meet that standard. So
I agree wholeheartedly on that.
Yes.
Okay. All right. Well, right now we will deny the request of rehearing, although we can't rehear it anyway because it's out of our jurisdiction. But just for the record, I will put it to the board for a vote of whether we were acknowledge, well, not really acknowledge, but but vote on whether we want to rehear this case or not at whatever appropriate time is necessary. So I will entertain a motion from that.
Madam Chair, given the statement by Ms. Wagner and the fact that it appears that it is no new evidence that is being presented in the request for rehearing, I would motion that we deny the request.
Thank you, Ms. Faith. Can I have a second?
Second.
Ms. Barnes with the second. Go ahead, call the roll, Ms. Cooper.
Thank you. Ms. Brown?
Yes.
Ms. Barnes?
Yes.
Ms. Faith?
Yes.
Ms. Brett?
Yes.
Thank you, Madam Chair. The request for rehearing on those 3 cases have been denied due to no new evidence, and we will send the appellant a letter this week.
All right, thank you.
Thank you.
All right, fun day today. Thanks, everybody. Have a good week.
Everyone have a good
Thank
week.
you. Thank you, everyone.
Safe,
See you next
safe.
week.
Thanks.
Bye.
Bye.
Bye, everyone.